It's 40 minutes past the hour of 6 o'clock. Let's go to our telephone caller. Aloha caller, welcome to the program.
Oh, Polka?
Yes, good morning.
Good morning. It's strange. I can hear you on the radio, but I don't hear you on my telephone. But anyway,
okay.
It's pretty good. I think I can listen with one ear there and the other one here.
Okay.
I almost, notice I said almost, hesitated to call in this morning. I don't like to belabor the subject excessively, but I do. And you referred in your opening statement to the increase or possible increase of the number of women in the Senate, I believe.
Yes.
That has to be looked at, like, say, from another point of view, and that is the history of most, if not all, of our institutions is they were usually started by women, teaching of the young, taking care of the sick, even religions. They were started in small groups, and these little cells gradually coalesced, becoming a system. Even in hospitals, they were run by nuns. And when they became so successful, the men immediately moved in and took them over. You can look at the Red Cross, you can look at medicine, especially obstetrics, and the death, taking care of the dead bodies, is now a major, very lucrative business run by mostly men. And even the most recent incident in these debates, where until quite recently, I don't remember the dates, but quite recently it was run by the League of Women Voters. And so apparently it became something that really attracted an audience. The men took it over. No fight about it, nothing. I mean, it was astonishing the way this seems to automatically happen. And so people could ask, well, why do women say yes so easily? Because they've been taught to be willing victims. That's another whole subject. But at any rate, to continue with this, it is obvious that the men have led the country to the edge, if not over the cliff, to use a very frequent phrase.
Okay.
So now, because they recognize this disaster, they want to call in Big Mama to solve the problem. As soon, if they can, put the pieces of this destroyed erector set back, men will move in and take over again. Now, I have asked the question of several very young women, knowing the history of this and how it has repeated itself, and there has been no way to get this, now listen to this word, polka, unbridled lust for power. You see how that word is used? And what it means?
Well, now it's taking on new meaning.
Yes. Words have a tendency to do that. So you can see why women are now going to be pushed back into a very appropriate, another word, wedlock. So we can see this history very clearly when someone points it out. Now, why haven't women rebelled in a stronger way? This so-called rebellion that's going on now by women in this war on women is very weak. It doesn't stand up and say what must be said, but isn't going to be. And that brings me to my final question. Why do men fear the power of women?
Okay, you expect me to answer that?
No, you're not.
Thank you.
I haven't heard anybody well, that's wrong. I've been reading some very good responses to that, which are really right on. But I'll leave you with that thought anyway. And I expect you to have an answer next week. You see, we're going to elect you to the Senate so you can repair the damage on demand. Okay, thank you.
I'll leave that question out there. Thanks for calling. Aloha.
Bye.
And if you or any of you would like to take on that question, go ahead, be my guest. Why do men fear the power of women? Okay, we'll leave it at that. I won't comment. Yes, I said I won't comment, so I won't. Now, I'm going to take a moment. I think I need to change this set of earphones so I can more easily hear what's going on. Hang on a minute. Let's get to some sweet music, and I'll be right back. Okay, there we go. The music in the background is about going out and visiting different places, Kaimanahila being Diamond Head. All right, thank you very much for that song. And that's from the Hawaiian Style Band. The song is Kaimanahila. In fact, now they're talking about, singing about Kapiolani Park, where I just took a walk around the park last night after the program last night, and I had to take care of my aching body, which hasn't done much walking more recently. Anyway, the discussion has been turned into why do men fear women, or the power of women. And if you would like to speak on that subject, you're welcome to call. I'm not going to touch it, at least not now until somebody calls. Let me report that something very interesting happened in the, I believe it was the Second Circuit, the Second Federal Appeals Court Circuit, a ruling in Manhattan, and this was on Thursday, that the federal statute, you familiar with the DOMA Act, the Defense of Marriage Act? And in that act, the federal law is that the federal government would not be recognizing marriage between people of the same sex. So the federal law says no recognition, and as a result, no consideration for the marital status of these individuals as regards tax laws. There was a woman whose spouse passed on, and because she didn't have the exemption for the what we call a pass through, whenever you have a spouse passing on, then you can just pass the full estate on to the surviving spouse. In this case, she didn't get that exemption, and she was charged with taxes of $363,000. Now, this is what we call transfer costs, or in-estate taxes. So she sued the federal government, saying that the federal law was discriminatory. It discriminated based on a person's sex. And here's what the report continues to say. Let's see. She sued, saying women unlawfully discriminate. So the law unlawfully discriminates against same-sex married couples by denying them equal federal benefits. So it's under the Equal Protection Clause of the Constitution. The court, the U.S. Court of Appeals for the Second Circuit, is the second federal appeals court to reject a central portion of the federal law, the Defense of Marriage Act, following the U.S. Court of Appeals for the First Circuit in Boston, which handed down its ruling in May. But this decision Thursday is the first time an appeals court has subjected the law to a relatively tough test for constitutionality that, in effect, elevates issues of sexual orientation to the constitutional level of cases involving sexual discrimination. The Supreme Court might take up the issue as soon as the current term. Two of the three judges on the Manhattan Court ruled in favor of Edith Windsor, an 83-year-old woman whose case challenged the 1996 statute, saying it violates the Constitution's Equal Protection Clause because it recognizes the marriages of heterosexual couples but not those of same-sex couples, even though New York state law makes no such distinction. Windsor, who filed the lawsuit in November 2010, married her longtime partner, Thea Spire, in Canada in 2007. The two had been together for 44 years. Although the marriage was recognized in New York when Spicer died in 2009, Windsor was not able to claim a deduction for a federal estate tax that is available for the surviving partners of a marriage between heterosexuals. Windsor, who had been the sole beneficiary of Spicer's estate, was forced to pay $363,053 in estate taxes. When she requested a refund, the Internal Revenue Service rejected her claim, citing federal marriage law. Judge Dennis Jacobs, who wrote the majority opinion, said the federal law was, quote, not related to an important government interest, in concluding that homosexuals are not in a position to adequately protect themselves from the discriminatory wishes of the majoritarian public. The statute approved by Congress and signed by President Bill Clinton denies recognition of same-sex marriage by the federal government. In the intervening years, however, several states, including New York, have approved same-sex marriage, although others have passed laws banning it. In February 2011, the Obama administration determined that the provision of the law that prevents the federal government from recognizing same-sex marriages was unconstitutional, and President Barack Obama said he had directed the Department of Justice not to defend that aspect of the law in court. Isn't that interesting? However, I believe it was out of the U.S. Congress, there were a group of people, mostly Republicans, I think it was all Republican members of Congress, who decided that they would divvy up the cost for carrying on the lawsuit, and it appears they appeared as a friend of the court defending the statute, while the federal government itself was, what is the word for it, was sort of like the straw man, having to stand in as a defender of the law but not taking an active part, and in fact trying to participate, suggesting that the law itself was unconstitutional. So this woman, Ms. Windsor, did succeed in having that portion of the law overruled. So it's quite a change in what we're seeing, the law now moving to recognize the legitimacy of these marriages. The division between the federal law and state law is as follows. The states determine whether or not, or they control marriages within the state. They also control whether or not they will recognize marriages from other foreign or alien territories, a foreign territory being from another state, and alien territory being from another country. New York had not recognized foreign or alien same-sex marriages, but they subsequently changed the law and itself adopted a law that does recognize it. The federal law, however, said that we will not recognize that type of marriage. The federal law essentially said that they will not follow or give credence to the state law that made that recognition. And in that way, the federal court says, no, 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 this is discriminatory. If the New York state says we find that the couples were married according to our definition, the feds have no right to discriminate and say we're going to step in and not recognize it. The feds are bound by the state determination. In this case, because New York did find that the marriage did exist, the feds were obligated to follow that ruling by the state. So in that case, state controls in terms of whether or not a party gets or does not get the marital deduction. In this particular case, what had happened is that the Second Circuit essentially said that while the state of New York has not yet determined on this case whether or not that marriage back in 2007, I think it was, or when she passed away, or no, I think the marriage was in 2007, whether or not the state of New York would have recognized or now recognizes that there was indeed a marriage, because in 2007 the New York state did not have a law recognizing same-sex marriage. At the time of the death of Ms. Spicer, the state did recognize same-sex marriage. So at the time of the death, it would have been recognized, but this was still undetermined. The clarity was not all there. The federal court for the second district says, in essence, never mind. What we will do is we will not impose, excuse me, not impose, but we will suggest that, no, they use another term for it, I forget the term for it, but we believe that the state court, the highest state court, would reach a decision consistent with our determination that they would recognize same-sex marriage in this particular case. So we're not going to spend the time of going back to the state court and asking that question. We are not going to certify a question to the state, and we are simply going to say that the state would have said this, and we're going to move on. And they, in the decision itself, which I took some time to read, found that they said, rather than wasting the time, this is our determination, and we fine for the taxpayer rather than for the government. Okay, so I thought that was a very interesting movement in terms of what is happening in this whole shifting of the American society, and how the greater acceptance of same-sex marriage is moving about, just as a recognition of the don't ask, don't tell policy in the military, things like that. You do see a shift, a more liberal shift occurring in the landscape of the North American area, now controlled by the United States of America. All right, with that said, let's go to some music.
Mai ka elele o ka loko ino, pala pala anunu me ka paka. Mane mai Hawaii moku o ke ave, koku ana honoa o Pilani, ka ko o mai kaua i o mano, pa'apu me ke oni o ka kuhi hewa. Aolea e kau i ka pulima, maluna o ka pepa o ka ene, sibila o ke kanaka Aole makoa e mina mina I ka pu'u ka